Welcome everyone to the Law, Ethics, and Animals program talk on Proposition 12 and the Supreme Court. We're just getting started here, letting a few people in from the waiting room. While we're waiting, I wanted to thank our co-sponsors, the Yale Animal Law Society, the Yale Environmental Law Association, and the Yale Sustainable Food Program for making this panel possible. A couple quick technical notes. We are recording this session, so if you do not want to be involved in the recording, you can log off now. We are hoping to fit a Q&A in, even though this is a short 1 hour panel. You can send questions in the chat to me, and we will do our best to try to get to them as we go. I'm going to introduce our panelists. Their bios are in the notice of the panel, but first we have Brian Frazelle, Senior Appellate Counsel at the Constitutional Accountability Center, who authored a brief in the case on behalf of law professors in support of Proposition 12. We also have Rucha Desai, who's a partner at Fairmark Partners, specializing in antitrust litigation, sustainability, factory farming, and greenwashing issues. She submitted an amicus brief on behalf of small and independent farmers and farmer unions in the case. And then we have Amy Chyao, who's a Supreme Court fellow with the Humane Society of the United States, who worked with public health and food safety experts, shepherding a brief on the food safety and public health issues related to the case. So that's our panel, and we're excited to have them here. I'm going to give a brief overview of the case. There's so many different ways to tell this story, and this is necessarily going to be a very condensed, we'll see how convincing it is, treatment of the case. But I want to start in 2004, because although there's a lot of cases and laws floating around on this question about the Dormant Commerce Clause and state authority over the sale of products, three significant things happened in 2004. First, Colorado had a ballot measure that enacted a 10% renewable energy mandate for all electricity sold in that state. That same year, California passed a ban on the sale of foie gras from force-fed geese. And then the third significant thing in 2004 was Florida passed the first ballot initiative banning the use of gestation crates for pigs in the food system. And if you don't know what a gestation crate is, you can Google it, but be careful because it can be a little bit rough. But this is essentially a device to hold a pig in the food system so that they can't turn around their entire lives that they're in there. So these three laws are significant because two of those three immediately go to challenge. So the foie gras and the renewable energy law are both challenged. And the common feature of these laws is that both of them say, we don't care where you produce energy or where you're producing foie gras. You can't sell it in this state if it meets or falls below certain standards of humane treatment or certain standards of environmental renewability, climate impacts. And in 2013, the Ninth Circuit rejects the Dormant Commerce Clause challenge to foie gras. And then in 2016, perhaps more significantly, a little known 10th Circuit judge named Neil Gorsuch writes an opinion upholding the Colorado 10% clean energy mandate in the face of a Dormant Commerce Clause challenge. That's not only significant because where Justice Gorsuch ended up, but because it was a non-Ninth Circuit decision on this issue. And so there were a number of Ninth Circuit cases looking at laws like this, whether it's Rocky Mountain Farmers Union and the California Fuel Economy Standard, shark fins, all kinds of different issues that had been upheld in the Ninth Circuit. But the 10th Circuit Epple case is significant because it's not the Ninth Circuit. So meanwhile, in California, there's a number of laws evolving around the sale of meat and eggs from inhumanely treated animals. And that starts with Prop 2 in 2008, and then takes us all the way to 2018 and Proposition 12, which is at issue in this case. And so, like the law in Epple, the Colorado Clean Energy Mandate, and the foie gras law in California, Proposition 12 says, we don't care where you're producing eggs, pork, or meat from veal calves. If you're going to sell it in this jurisdiction, it has to meet certain standards of humane treatment. And so under 10th and 9th Circuit precedent, this is absolutely kosher. And so every challenge at the lower level to this law was rejected. And so the egg industry decided, we don't want to challenge this law. We're going to focus on switching to cage-free systems. But the pork industry decides to fight. And so they file a series of cases attacking this underlying standard that had been established in the 9th and 10th Circuit and elsewhere, that when a law simply says, we don't care where you produce something, we're going to ban the sale of it here because of a problematic environmental humane issue, that's perfectly kosher. And they lose all of the lower court cases on this, but ultimately the Supreme Court earlier this year decides they're going to hear the case. And that's how we get where we are now. And obviously the argument has big implications for animal welfare and renewable energy and a lot of other issues. And I think the way it could adversely affect animals is pretty clear, given the number of laws with respect to prohibiting the sale of dogs who are raised in puppy mills, or testing on cosmetics, or preventing the trafficking and poached wildlife. But in keeping with what we do here in the LEAP program, we wanted to explore a little bit how this connects to other issues and other social justice issues. So for those of you who made it through the 2.5-hour argument on Tuesday, I'm sure you noticed that this case did not break down along the traditional party lines. And that's not unusual in animal law. And there's just a lot of different interests at stake and a lot of different questions. So I'm going to shut up now so we can dive in and talk to our panelists and learn a little bit more about this. And if you've come in late, we are going to try to do a Q&A at the end, and please send your questions directly to me in the chat. So I thought maybe we'd start with Brian, and maybe you could help us just understand this dormant Commerce Clause issue that's front and center in this case, which I think Justice Gorsuch referred to as the most dormant of all dormant Commerce Clause questions in the argument. What are the basic parameters we're dealing with, and how do we wrap our heads around this for people who maybe aren't steeped in this the way you and I are?
Sure. So I'll start by explaining what the Dormant Commerce Clause actually is. Essentially, this is a doctrine that limits states' ability to enact laws that affect interstate commerce, which means commerce that crosses state lines or that affects more than one state. And even though this doctrine has been around for a long time, even among lawyers, it can be a little mysterious, in part because it has a misleading name. There is no dormant Commerce Clause in the Constitution. There's a Commerce Clause that gives Congress the power to regulate commerce among the states. But that clause doesn't, at least not explicitly, say anything about state power to regulate commerce among the states. It doesn't say whether states can also regulate interstate commerce. So the question arises, well, is Congress's power to regulate commerce exclusive? If it is exclusive, states can't regulate it at all. And so even when Congress has not regulated on a particular topic, like animal confinement standards, are states implicitly precluded from regulating in that area? In other words, when Congress's power to regulate commerce is lying dormant, can the states operate in that area? And so that's where we get the name Dormant Commerce Clause, the idea that the power to regulate commerce is lying dormant because Congress hasn't regulated on a particular topic. So which is it? Can states regulate interstate commerce or not? What the Supreme Court ultimately decided in the 19th century is sometimes they can regulate it, sometimes they can't. The court essentially split the difference and said that states can pass laws that significantly affect interstate commerce and even regulate interstate commerce, but there are some limits on what states can do, even when Congress hasn't weighed in. And so those limits make up the Dormant Commerce Clause. Now, what those limits actually are has changed over time. The doctrine has evolved a lot since the 19th century, and the court has repeatedly altered the standards that it uses to evaluate state laws. But today, in the modern era, if you read a Supreme Court decision addressing this doctrine, the court will explain that there are two basic questions that you ask about a state law under this doctrine. The first question is the state law a protectionist measure? Does it discriminate against commerce from other states? Does it try to promote a state's own industry at the expense of competition from other states? And those kinds of laws are almost always struck down. And there are good reasons for that, because if states could engage in trade wars, you'd have a real breakdown potentially of the sort of economic union. Significantly, Proposition 12 is not discriminatory. It's not a protectionist law. It treats all pork the same, regardless of where it was produced. And the pork producers concede that. So that is just off the table right from the start. But that's not the end of the story. The Supreme Court also says that even when a law is not discriminatory or protectionist, the court says that courts are supposed to apply a balancing test. Essentially, the idea is that if a state law imposes burdens on interstate commerce that clearly outweigh any local benefit to the state, then the law can be struck down. This is associated with a case called Pike v. Bruce Church, and so it's sometimes called the Pike balancing test. Essentially, courts are being asked to weigh the value of a state's law against its interference with interstate commerce. And the reality is that very few laws are struck down under this balancing test. Now, the pork producers do bring that kind of claim against Proposition 12, and they claim that the law is going to have significant detrimental effects on interstate commerce because they claim it's going to lead to a transformation of the pork industry. And they also claim that, conversely, the law doesn't provide any legitimate benefits for Californians. They say it doesn't actually protect the health and safety of Californians, and Californians have no valid interest in how animals are raised in other states. So that's one of the challenges the pork producers bring. But there's actually more. The Supreme Court has said that although those are the two main strains of dormant commerce clause doctrine, there are some other variations and exceptions. And there are a handful of cases in which the court has struck down state laws that attempted to regulate commercial transactions in other states, even when those transactions had nothing to do with the state that passed the law. And so this is the doctrine that the pork producers are primarily relying on. And they are arguing that those cases stand for a very broad proposition, which is that anytime a state law has ripple effects in another state that lead businesses to change how they operate, that means it can be invalidated under the Dormant Commerce Clause. And so what they say here is that even though Proposition 12 only regulates sales of pork within California, what they're saying is that as a practical matter, because of the nature of the pork industry and how it's going to react to Proposition 12, they're claiming that the pork industry is going to put changes into effect that are more far-reaching. And to them, that makes the law invalid under the Dormant Commerce Clause. So that's the most far-reaching and broad of the arguments that the pork producers have made in this case. And it's the one they've really been emphasizing in their briefing and in the argument.
Great. And I want to come back to that concept of causation versus control in the marketplace with respect to what California is doing. But what was your impression of the argument on these issues? And in particular, you mentioned that some of the doctrinal questions about the very existence of the Dormant Commerce Clause. Do you think there's any chance of 5 votes for either curtailing or dispensing with it in some capacity? We heard some pretty strong positions from Justice Thomas and Justice Gorsuch, which of course were not a surprise, but I was curious about your impressions about that and anything else about the argument that might have surprised you or have been interesting.
Well, it's an interesting doctrine because it has been controversial for a long time, and many of the justices who are most associated with originalism, conservative justices like Justice Scalia and Justice Thomas, and it seems clear now Justice Gorsuch, they are pretty skeptical or outright against the Dormant Commerce Clause doctrine. So I think it was pretty clear from the argument that the pork producers are not likely to pick up the votes of either Justice Gorsuch or Justice Thomas. Justice Thomas said pretty much outright that this law does not reach out beyond California's border and try to regulate conduct in other states. And Justice Gorsuch essentially said that the pork producers here are trying to inscribe non-textual economic liberties into the Constitution, and trying to gain constitutional protection for their own particular production methods. So that was interesting. And you mentioned earlier, that's one of the reasons that I think the arguments didn't seem to split down the sort of typical ideological lines. More generally, I mean, I was pleased to see that I don't think that the pork producers made a lot of headway with their extraterritoriality argument, the very radical, far-reaching argument that they've been making. I didn't see or hear much enthusiasm for that argument among any of the justices. And perhaps the most telling thing in that respect is that Justice Alito, who seemed to be the most sympathetic towards the pork producers, he immediately and repeatedly kept steering the conversation away from the extraterritorial doctrine and back towards the other argument about applying this balancing test. And so I was pleased to hear that. It suggests to me the court, I would be surprised if they did anything radical in terms of reining in the Dormant Commerce Clause, but I would also be surprised if they did anything radical in terms of expanding it the way that the pork producers are asking for.
Yeah, it really seemed like they kept moving away from the basic pike balancing test that we all sort of know and hate in some capacity. And I think that they would move away from it, and then they would get tangled up in various hypotheticals, and then they would circle back to pike as some kind of sort of safety spot for them in that argument. I wanted to ask you, because there's no way to talk about this argument without talking a little bit about hypotheticals. What was your impression of why so many hypotheticals came up? And in particular, did you get the sense that those were about things states could potentially do right now, or were really going to change in light of what the court does here? I was sort of struck by the question of, are these pre-existing hypothetical questions, or the outcome here significantly going to change it, if that makes sense?
Yeah, there were a ton of hypotheticals, and although, as I mentioned, I think the pork producers ran into a lot of trouble on their end, it's also true that when our side was up at the podium, a lot of the justices from both sides of the bench, so to speak, seemed to express a lot of concern, or questions at least, about one of the bases for Proposition 12. So there are two purposes behind Proposition 12. One is to reduce the risk of disease that is associated with these close confinement practices of animals. It's a health and safety rationale. But the other is a moral rationale. It's to prevent Californians from having to subsidize the production of pork in an inhumane way. And this latter purpose, this idea of moral objections to how a product is produced, justices really seemed interested and concerned with how far states could push that idea, because you could imagine lots of situations, and these came up in the arguments, in which states sort of are trying to influence political or social policies in other states, and they sort of repackage those concerns in a law that is geared toward the products of another state. So, for example, a couple of the hypotheticals that were thrown out in the argument were along the lines of, could states ban products from companies that don't offer their employees certain kinds of health benefits, for example? What if the companies don't provide for gender affirming surgery? Could another state ban products from that company? Or could a state ban products that were made with labor from undocumented immigrants, for example? So the justices, a number of them, really seemed concerned with figuring out if there's a place to draw the line that would prevent states from essentially trying to use these kinds of product regulations as a way to push their own policies within the boundaries of other states. And those are tricky questions, and I think that's perhaps why so much of the argument was spent on those questions, even though, as I mentioned, there's a whole separate basis for Proposition 12.
Yeah, one of the things that really struck me in that regard was that if you just walked into the argument in the middle and didn't know any of the background or read any of the briefs, you might think that the whole case was just about the question of what is the extent of state police power and whether or not California's law somehow drops below rational basis in some kind of substantive due process sort of argument. And I realize how that's part of the Dormant Commerce Clause, because you need to know the basis for it before you can potentially balance it. But it really surprised me. And I saw kind of two classes of these hypotheticals, right? So there were hypotheticals that were clearly discussing what sounds like a collateral business practice, right? So if you're talking about whether employee healthcare plans cover things that are currently subject to the culture war, that feels very collateral to the production. But then there were questions about things more tightly connected to the production process, whether it's inhumane treatment of animals or problematic labor practices. And it felt like the first category was a little easier to dismiss because it felt like a collateral business practice unrelated to the product, but the second category was a little closer. And I wondered if you had a thought about that, or if that is even a worthwhile distinction.
I think it is a worthwhile distinction, but I think one way to think about it might be that when the objections that a state articulates to a particular product, when they don't seem closely tied to the actual product, then it really starts to look like the state law is a subterfuge. It's a covert attempt to try to do something impermissible, rather than a valid attempt to protect either the health and safety or the moral values and priorities of a state's own residents. But it is difficult to draw those lines.
Yeah, and it really felt like so much of the argument was not about what was at issue in Proposition 12, but what might be issue in the next case, and the next case, and the case after that. There was a very little discussion of the actual measure. And I think those collateral impacts is a good time to bring Rucha in and talk a little bit about her brief and her clients. And Rucha, I think I promoted you to partner in your introduction, so I hope that sticks.
Yeah, I was gonna say, I'll take it. That's fine.
Well, I think one of the interesting things in the argument that came up was at one point the National Pork Producers Council said, as big ag companies are prone to do, oh my gosh, justices, you need to be with us because the poor small farmers are going to be adversely impacted by this measure. And I know that your brief took a very different take, so I was wondering if you could talk about that a little bit.
Yeah, definitely. So, I think the thing that's most important to remember is that farmers are not some sort of monolith. So while we do have large pork producers that are vehemently opposed to Proposition 12, there are small and independent farmers all across the country who welcomed Proposition 12. And these farmers were either already in compliance with the law or exceeded the requirements of the law, unrelated to what California wanted. They may have already decided this was their preferred model of production. Or there were farmers who spent the last 4 years investing in new confinement systems to be in compliance. And these farmers actually are capitalizing on an unintended ancillary benefit of Proposition 12, which is to inject some diversity in this kind of homogenized production model we have. Our brief looked at how the pork industry has consolidated over the last 50, and especially the last 20 years. And we've gone from, having multiple, thousands of small independent farms to, I think now 4 pork producers own more than 2/3 of the pork processing market in the United States. And with their market power, they're able to control all aspects of the supply chain. So from, breeding to feeding to slaughter to processing, they have a say in every single aspect of production. And, for reasons of efficiency, they have contracted with small farmers and what we call these captive production contracts that kind of eliminate any of their own market power and will, and they're sort of subject to very specific requirements of these pork producers. And what ends up happening is the entire supply chain looks the same. There's a completely homogenized method of production. And so now what Proposition 12 has come and done unintentionally is inject some diversity into the supply model to match what was already a diversifying demand. And these small farmers are happy to step into a void that is created by big producers leaving the California market. So I think Gorsuch actually had some great questions in relation to this, where he said, and this is rooted in principles of antitrust and fair competition, where he said, the harm that is critical in this analysis is not harm to certain interstate firms or producers, right? So if a few big pork producers say, hey, we don't want to do this, we're going to leave California, that's totally within their right. The harm that is critical to this analysis is whether there's been harm to interstate commerce or competition. And since we have all these small farmers who are ready to step up and start selling to Californians who have demanded this product, we see that the harm to interstate commerce has not been plausibly alleged.
Yeah, and Justice Sotomayor picked up on this as well, that the idea that this is a monolith, there are, even among the big producers that aren't your clients, there's a difference of opinion about whether or not they're going to supply this. And I think that's really interesting, right? Because traditionally, in a Commerce Clause analysis, as you note, the idea that individual firms might be financially impacted is not enough. We have to look at actual impact on the interstate market. But so much of the argument seemed to be assuming to some extent that this sort of specific harms to specific firms could be remanded and brought in to some kind of balancing analysis. And I don't think the court, even though it was 2.5 hours, got very far into the specifics of that, and the fact that a lot of that harm that they're alleging, which is the decision between serving a market or not serving a market, which the Chevron case and others have said don't matter. I don't think the court really grappled with how that might work on remand, and gave courts a lot of guidance on, and I guess if they remand on this basis, hopefully they do provide some guidance about how to do that, because this isn't a price control statute, and they've conceded no direct regulation of out-of-state transactions. They're really saying that because of the impact of what California is doing on the market, out-of-state producers, for some of the reasons you even noted about the control of the means of production, is going to shift to a all crate-free system, and therefore California is somehow legally causing that, which is problematic, but we don't have to get into that. But this question about what happens in the marketplace was very front and center in the briefing, but it didn't get a lot of traction in the argument. And I wondered if you had a thought about that.
No, well, I actually noted the same exact thing, that there were particular themes that didn't get as much airtime. And one of them was this, which is, what we're really dealing with is kind of very fundamental principles of supply and demand. And we have this ballot measure that was passed by a 2/3 majority. So we know that the majority of Californians are demanding this product. And producers are now have the choice to either supply this evolving demand, and sure, there might be adjustments they have to make to their model, but that's the cost of doing business, or they have the choice to sell pork elsewhere. But what the producers cannot do is have a court legally dismiss consumer demand because there may be certain changes required to the supply model. And I worry that a significant implication of a result of petitioner's ruling would be that now we can ask the court to protect certain players in the industry, regardless of the effects on interstate commerce. And I think particularly now in 2022, when there are a lot of large industry, a lot of big industries, big with a capital B, we're talking not just big pork, but there's, we have big tech, for example, where we have certain players that have such complex and interconnected vast supply chains that almost by default, any state regulation would impact their preferred method of doing business. I worry that ruling for petitioners would allow now any big firm to say, well, hey, this regulation is going to impact me and just a few other big firms. And now the court has set a precedent that that allows you to get protection from the court for your individual company.
Yeah, there's an interesting parallel there, right? So the large producers use their market power and the control of the packing system as a way to exercise undue influence on the individual farmers. And one way to actually look at their claim is they're now saying, well, actually, the fact that we're in this, integrated supply chain, we now want to use that same market power to restrict the ability of states to regulate what we're doing, and sort of using that to bully the states the way they've bullied the small farmers.
Yeah, we essentially now have a system where you're, too big to be regulated.
Right.
So, for a variety of reasons, consolidation has happened in the pork industry. It hasn't been, their power hasn't been kept in check, and now they, with the same power, are able to kind of immunize themselves from any sort of regulation.
Yeah, that was one of the arguments that was in the briefing that really didn't get a whole lot of play, even in 2.5 hours, was this idea that part of their argument is because of the way we've evolved the industry and the amount of market power we control, we're too big to be regulated. Too big to regulate, the flip side of that did get a lot of airtime, right? The idea that California has a big enough market share that somehow that their actions in regulating in state might be viewed differently than those of Rhode Island, which feels like a really problematic constitutional theory, that would be different based on the size of an individual state. Did you have any other impressions or surprises about what came out in the argument on Tuesday?
I was particularly struck by what you said. You've already said about support for California not necessarily falling on party lines. There was one more thing that I thought was worth mentioning is Gorsuch's reference to Justice Gorsuch's reference to Lochner. I think it was a very good parallel, because what we are seeing here is petitioners are effectively asking the court to protect an economic liberty, which we know from our first year of law school is not a right that's rooted in the Constitution, something that we've tried to move away from for a century. And it's interesting that we've come back to that. And I wonder, I was surprised that didn't get a lot more, airtime from the courts, from the justices.
Right. Because there's so much to unpack there, right? In an environment where the justices are saying that we're not going to recognize individual rights unless they're specifically written into the Constitution, we're toying with the idea of reviving some kind of Lochner type right, if not to necessarily trump state moral, humane, environmental interests, but to get a hearing in court where you're asking the judiciary to simply weigh the economic impacts on industry generically versus the state's moral interest or the state's environmental interest. And one friend quipped in response to that idea after the argument, can we get a jury trial on that, on whether or not industry costs outweigh state moral or environmental interests? And so what it looked like was, at some point, some of the justices near the end were thinking, well, we can bounce this all back to Pike balancing, where all these questions can get raised. And then I think Jeff Lamkin raised the specter that you pointed out, that would be essentially a Lochner type analysis that the federal judiciary might not want to sign up for. And my read, and of course, from my position at the far end of council table, I could only see half the justices, was that kind of set them back on their heels on that idea that maybe we would just remand it. So I want to bring Amy in and talk about the public health question a little bit, because one of the things that really struck me was that, and I'm always interested in where council go in argument that's different than what they put in the briefs, but the NPPC's counsel seem to, and even the counsel for the solicitor, the United States, seem to be accepting of the idea that health and safety would trump all of this, that even if a measure would otherwise be unconstitutional under the test they were advancing, that public health and safety, if that's there, then we sort of veer off that path, which is interesting in a lot of ways. So Amy, I wanted to ask you your impressions of the discussion of health and safety, and what surprised you, if anything, about what came up during the argument.
Yeah, thanks, John. I agree with you. I found that really interesting. There were a number of switches from the briefs to the oral argument on the other side. So what really jumped out at me as far as public health during the argument was Justice Sotomayor. And I think anyone who listened and was maybe tuned into public health, it probably jumped out at them as well. I know you Yale kiddos are going to be doing the reading, so I'll give you page numbers. So Justice Sotomayor and Tim Bishop had a really interesting exchange about public health. It's on page 12 of the transcript. And so Justice Sotomayor went into great detail on what she called a brief from scientists, and she talked about antibiotic resistance, and also the issue of new diseases jumping from animals to humans. And so what she's referring to there is an amicus brief that was submitted by the American Public Health Association as the lead, and a bunch of other really great groups of experts and individual experts. It was drafted by a firm called Sherman and Sterling, and I want to recognize Joy Wong, who's the associate who drafted it. So on pages 1 to 5 of that amicus brief, you can see just how strong the credentials of not only those scientists are, but there are also physicians, veterinary experts who also have backgrounds in public health, public health experts in total, including all of the memberships of those groups that signed on. It's tens of thousands of experts behind that brief. So I'm really glad that Justice Sotomayor recognized the weight of that brief and started engaging with the science a little bit. And I won't do too much science. Just what I'll say is the couple of topics I would kind of like a yes and in improv. Yes, what she pointed out, and I would say that the topic of food safety is really central to public health in this case. And you can read all about that in that amicus brief. And just fundamental to both food safety and infectious diseases, there's just the idea that extreme confinement conditions really promote an environment where disease can spread, whether it's disease that can get into pork that ends up on California grocery shelves, or it's disease that can end up in a local outbreak, an epidemic, or a pandemic. So these are really key health interests, and I was really glad to see that Justice Sotomayor was focusing on them.
Yeah, I picked up on that as well. And I think one of the interesting things that didn't get as much airtime, but got a little, was where the burden lies in this, right? So in the briefing, it was all over the map, right? So the California and the interveners cited Walsh and Cloverleaf and said, look, this is essentially a rational basis challenge, that if you're saying that you disagree with the state's scientific conclusions, if there's essentially any evidence in support of them, it's not irrational, that's it. And then the pork producers seem to think, like at the highest level, that the state had to prove their scientific purpose with peer-reviewed science, and almost incorporating kind of a Daubert kind of frame into their argument, although they didn't say it directly. And then the United States had sort of a middle position, which, you sometimes think when people aren't sure what to do, they go with what they know. And it was sort of an APA challenge. Like, we're going to treat the question of whether California was within its police power as an APA case, and California has to make some kind of substantial showing of their purpose. And there were even questions in some of the brief about what was before the voters at the time they made their decision, which are sort of classic APA formulations that don't usually make their way into a constitutional analysis. Did you have a thought about that or a reaction?
Yeah, absolutely. I think, and this is something that only came up at the very end of the question portion of the argument. It's on page 140 of the transcript. But there was a really interesting exchange between Justice Jackson and Jeff Lamkin, who was HSUS's counsel. And Justice Jackson basically raised the idea, okay, we're here on a motion to dismiss. What I thought this was the standard, and so you seem to be arguing something different. So just clarify that. And this is something that it was pointed out in the briefing. From our brief, it says this great line. It says petitioners never acknowledge the daunting burden they confront, and that specific burden is a case called Maine v. Taylor. And so. Unfortunately, I think that time sort of ran out when he started to talk about this, but I'll just mention this point that Maine v. Taylor, as Jeff Lamkin started to say, was a case where there was facial discrimination. And as Brian said earlier, Proposition 12 is not discriminatory. It's not protectionist. So, but even in a case of facial discrimination, there was a huge burden on, in this case, analogously, it would be the petitioners. And so basically, I feel like, Maine v. Taylor is pretty much the most on the nose precedent here. And I think it was interesting that came in just near the end there, but I think that would be what should control here.
Yeah, and everyone will drop off the Zoom when I raise Civ Pro, but this also the question about how much they have to allege, right? So there's clearly a scientific debate on this, and of course the California and the proponents all believe that they have the better side of the debate. But it seemed to be what MPPC was saying was, if we simply allege in a complaint that there's no evidence, that's enough to get past the motion to dismiss, even when there's clearly a debate among the science, and the idea that simple denial would be enough. And of course, that's my biased viewpoint of what their complaint says, but their complaint and I thought most tellingly, the industry swine vets that submitted a brief admitted that there's some evidence that providing more space and exercise improves health welfare for the piglets, and that it reduces stress. So once we're in that space about arguing over the science, it'll be very interesting to see if it does go back on remand, or there's a later case, how the courts will deal with a scientific dispute that would be very quickly disposed of under the APA, and probably pretty quickly disposed of under rational basis, and whether or not we're going to impose some higher standard of showing on states under the Dormant Commerce Clause in order to change that standard of review. So I think we'll start taking a few questions and as a group. I think the first question is one that I'm very interested in, which is, there seemed to be a distinction in the argument between moral interests and public health and safety. And the question is there really a difference between a moral interest and a health and safety interest? And are those things, as distinct as they were treated in the case? Anyone want to take a stab at this question?
I mean, I could start. So I think in one sense they aren't distinct, because when states do pass health or safety measures, and really any kind of law that attempts to protect the residents from a particular type of harm or promote a particular value, those are always driven by moral concerns. It's the moral concerns of the legislators or in the case of a referendum, the voters. So in one sense, everything is driven by, all laws are driven by moral concerns. But on another level, there is some distinction, I think, because with respect to Proposition 12, for example, the moral concern, although there are separate concerns about the actual product, the pork itself, and the pigs associated with it being dangerous to human health, the moral concern is a separate one. It's about the idea that California voters, when they go to the supermarket and buy pork, they don't want to feel like they're complicit in promoting or subsidizing these production methods that are cruel and inhumane. And so in that respect, some kinds of moral concerns about how a product is produced wouldn't necessarily be associated with anything about the product being dangerous. And I think that's the way that you can draw a distinction here. I mean, as I mentioned, with Prop 12, you have both of those concerns, but I think that's the distinction.
Yeah, I think my suspicion is courts treat them differently around the standard of review questions we've been discussing, right? So when a state asserts a health safety interest, there's a feeling that, well, we can pull out the science and pull in experts and we can see what's there and gauge the strength of the science. And regardless of, we can have debates over where you're going to put the standard review, but ultimately there feels like there's something more objective for a court to be comfortable assessing. And when we get to a state's moral interest, you know, interestingly, the question about how you assess a moral or religious interest has come up recently, right? We see the question of complicity in Hobby Lobby and Little Sisters of the Poor, and the court essentially saying, we're not going to get into the business of second guessing whether these interests are cognizable. If it's an asserted moral interest, that's going to be enough. So it'll be very interesting from an animal law perspective to see if the court treats the interest in avoiding being complicit in cruelty differently or requires some different showing than other moral interest complicity interests. So I think that'll be an interesting thing to watch.
If I could just one more quick point.
Go.
This goes to the reason that the Dormant Commerce Clause in general, for many people, is a very controversial doctrine, because it, at least the part of the doctrine that involves this balancing test, it puts courts in this position of trying to weigh things against each other for which there's no objective way of weighing them. You know, it's not really a judicial task to try to figure out whether preventing animal cruelty is more important than raising or not raising prices for pork. There's no judicial metric for that. And so that's why, you know, this pike balancing, which during the argument seems to, at least some justices, prove maybe an attractive way of getting rid of the case without saying too much, in practice, it can be pretty problematic because of that aspect of it.
Amy or Rucha, do you have any thoughts on that one, or should we go to the next question?
You know, the only thing I'll add is that I think that was another issue that I did not think received enough airtime, which is really the questioning what the court's role is in this entire analysis. Because I think Justice Gorsuch and I think maybe Justice Kagan had asked, you know, who are we to be questioning whether, you know, this might be an adequate remedy to for public health issues, or this is an adequate remedy to inhumane conditions of you know, certain livestock. That's really not the court's role here. And I kind of wish that had received more airtime, because there was a lot of discussion about the merits of the law, but I don't know if that's actually, that's not really the court's role to question the legislature.
Yeah, there was a sense to me that having taken the case, there was a pressure to grapple with the big issues and a reluctance to, you know, spend 2.5 hours talking about Twombly, right? Like we're at the Supreme Court now, and maybe, you they want to say something more meaningful, even if it might not be the right place and time for that. Okay, here's one that's near and dear to me. What particularly bothered me about the federal government amici position was that the council seemed to be arguing the merits and dismissing moral concerns. Thoughts? This was interesting because although the USA brief essentially said, we're not taking a position on extraterritoriality, but we do think they've alleged enough to have their pike claim proceed to discovery and potential trial. The argument from the solicitor, and I think I don't know if it was Justice Jackson or Justice Kagan called them out on this. They seem to be going quite a bit further in their argument before the court than where they were on the brief. I don't know if any of you want to comment on that.
I noticed that too. I don't remember which justice it was, but I do remember a specific question or remark that was, oh, wow, you seem to be, this is a much stronger argument than what you said in the brief. I don't really have a strong kind of opinion on that, besides what I just found a bit frustrating about the United States brief, which was that it obviously, if it does speak to the extent it does speak to the merits of the issue, the U.S. brief would obviously have a major influence on the outcome of the case. As we noted before, the case is not just about this specific industry, but it had implications on all sorts of big industries kind of across the spectrum. And it seems like they did wade into the merits at oral argument and kind of thumb the scale a little bit.
Yeah. Other thoughts on that one? We have plenty of more questions here to follow through. Okay, here's an interesting one. I've seen jurisdictions implementing ag-gag legislation that don't have clauses for ensuring animal law enforcement. Is Prop 12 making sure new laws are policed, or does it leave that up to enforcement agencies? I'm not sure that's perfectly clear in Prop 12. I will start the answer on this, and if anyone wants to weigh in. The question of enforcement actually was front and center in the briefing. And interestingly, I don't recall it coming up in argument to the degree it did in briefing and in the moot court, which is the fact that California, in implementing Prop 12, although Prop 12 doesn't say anything about using California inspectors to look at farms that are out of state, the regulations that the agency has promulgated do authorize that. And it felt to me in the briefing, at least, that the pork producers and their amici were making a lot out of that to say that the fact that there are out-of-state inspectors, as opposed to the direct operation of the law, was itself an extraterritoriality problem. Any of you have a thought on that?
I have a brief thought on it, which I always found that argument strange in the briefing, because these regulations are not even properly before the court. They were only recently went final, and I mean, as all of the law students who've done some basic administrative law know, there's a whole administrative process, and that would have, that you'd have to go through to challenge those, and if you wanted to, and then bring a separate case on that. So I always found that strange, and it's also not factual that California inspectors would need to be going into Iowa farms. I mean, it's pretty commonplace in other types of inspection programs, similar ones that third-party inspectors would be used. But I always found that aspect of things interesting. I thought it was completely irrelevant from the jump.
Right, but maybe contributes to the overall rhetorical flavor of state overreach, right? Yes. To sort of point this out, even though it exists in a lot of other areas.
Yeah, atmospherically, the pork producers really used that to bolster their rhetoric and the idea that if you're sending California inspectors into other states to inspect what's going on inside pork facilities, that really starts to seem as if California is trying to regulate the nation. Right. But that's really not a valid description of what would happen for the reasons that were explained. If you can invite California inspectors into your facility if you want to sell pork into California. If you don't want to sell pork into California and you don't want to comply with Prop 12, you don't have to do anything. Yeah.
Let's hope they don't find out that there's French and Belgian and other European inspectors in American plants right now inspecting for the meat that goes for export, right? This is not an unusual thing to have the market regulators present, because it's actually a benefit to the producer in order to open those particular export markets. Okay, here's one which will be impossible to answer in 4 minutes, but we have to face it. Hi, there's been a couple articles written about Prop 12 decision and abortion rights, specifically using the Dormant Commerce Clause to restrict travel of women seeking out-of-state abortions. What are the speakers' thought on this? Do you think the justices will vote along the same lines they did on abortion rights? Anyone want to brave their way into that? Or I can start and others can continue.
I can take a very tiny piece. I'm not going to take the hard part, which is that so someone else could do that. As John said in the beginning, I think it's pretty clear from the lines of questioning in the argument that this one is not likely to fall on what some would call partisan lines. So I think that aspect of the question, I don't think it would be the votes would fall in the same way.
Yeah, what interested me actually was that Kavanaugh went out of his way to mention this question in the Dobbs decision about interstate travel and the right to travel, which of course is a whole nother webinar about the right to travel and what it might mean. I guess my impression is, and my impression of the Dormant Commerce Clause in general from the argument and working on this, is that this is a pretty limited doctrine no matter how you slice it. And the chances of the Dormant Commerce Clause being a significant restriction on state laws involving abortion is pretty low, right? It's a very difficult doctrine to wield in the absence of overt economic protectionism. And so I actually don't think what happens here will have a significant effect unless we think that this Supreme Court would ever have 5 votes for the proposition advanced by the petitioners that moral concerns can never be a valid ground for state legislation. And so I think that could be relevant to the abortion discussion where they are now, but I don't see this case changing that reality of where they are now. I don't know what you all think about that.
I also have not seen much connection personally between the arguments at play in this case and the arguments that might come into play if states started to try, pass measures trying to restrict travel or restrict abortion pills being mailed, sent through the mail. The Supreme Court could reject the pork producers' challenge and essentially leave the Dormant Commerce Clause exactly the way it has always been, or the way it has been for decades now. And the arguments that the pork producers are making are so uniquely tied to specific claims about the structure of the pork industry and their ripple effects that will occur as the businesses adapt to Proposition 12. It just doesn't seem to have anything to do with the doctrines that would come up in those kinds of potential future legal challenges, at least to me.
Yeah, it's interesting. There was so much discussion about, well, if you allow this, all these horrible things are going to happen. But the allowing this means affirming a line of cases that's been in effect for more than a decade. And as much as I would love to say that animal advocates came up with this brilliant, devious idea for Prop 12, it is so similar to so many other laws that have passed that this authority is going to exist, one way or the other, absent a sea change in Commerce Clause theory. So we have 1 minute left, and I thought maybe I could press you each for a snap prediction on what the outcome might be. Maybe starting with Amy, and then we go to Rucha, and then Brian.
I'm cautiously optimistic that we can prevail, but I think no matter how it shakes out, I don't see it being more lopsided than a 5-4 or 6-3 is my guess. Got it. Rucha?
I'm generally not an optimistic person, so I think we're gonna see remand, and I think it'll be a 5-4 as well.
Brian?
I've kind of sworn off predictions, but I think, as I mentioned earlier, I just I would be very surprised if the court adopted the very far-reaching territorial-based arguments that the pork producers are making. But it does seem within the realm of possibility that they would remand the case and
Yeah.
you know, under the pike balancing test, which you know, would mean the pork producers would actually have to prove that what they're saying about Proposition 12 is true, and so maybe that won't be such a bad thing.
Right. Well, since I pressed all of you, I will say that I agree. I don't think they're going to go for the big extraterritoriality argument. I don't think there's 5 votes for that, but I do think there's a fair chance they could remand on pike in order to avoid what seemed like a lot of sticky hypotheticals to the court during the proceeding. So I'm sorry if we didn't get to your questions, but I think we got to almost all of them. And we will hopefully be posting the audio. So thank you everyone for joining, and thank you to our panelists for taking the time, especially this week, to chat with us about this case. Everyone have a great day.